JCPC, Attorney General Trinidad and Tobago, and Maharaj.
Good morning, my ladies, my lord.
Good morning, Mr. Clayton.
In this appeal, I appear together with Mr. Ram Logan and Mr. Richards, and my learned friend Howard Stevens, Queen's Counsel, appears.
We know Mr. Stevens.
Yeah.
I'm sure you do. I've only had the pleasure today.
Instantly forgettable.
May I begin by apologizing about the fact that we've had to put in a supplementary bundle, which is quite short. There is also, which I'll come to pretty quickly, a speaking note that I've drafted, which has tried to crystallize the construction submissions, which we hope will make it easier rather than more difficult.
Well, it is quite a short point, Mr. Clayton.
It is quite a short point. I mean, I don't...
I'm not suggesting it's easy, but it's quite short.
With respect, I would adopt both those points. It isn't entirely easy. But if I could just briefly introduce the case, if I may. As your lordships will be aware, effectively the immediate cause of this litigation was the resignation of the Chief Magistrate, Mrs. A.S. Caesar, from the High Court, and the subsequent controversy which surrounded her appointment. As my lords and ladies will know, that attracted concerns from the Trinidad and Tobago Law Association, who intervened in the first instance hearing, and so far as we are aware, made an application at some point to intervene in these proceedings. The position, which is of some factual significance, is a last appointment exercise, if I might call it that, took place at a time when the Judicial, Legal and Legal Services Commission comprised 4 members. And as my lords and ladies will know, there are 3 issues in this case: how many judges can be appointed, whether the commission must constitute 5 members, and what is the impact or effect or implications of Section 36 of the Interpretation Act.
But I thought the last 2 questions were agreed, the answers to those.
No, not Section 36.
You don't agree that if there's a vacancy, Section 36 applies to validate the actual act?
Precisely.
You don't agree with that?
We don't agree. We say that, for a set of reasons, that ordinary legislation can't have the effect of legitimizing a prospective breach. I'll look at Section 36 in a bit of detail, but the bottom line with Section 36 is so far as it takes anything, it's concerned with relief. The current version of Section 36 effectively debars a remedy of certiorari, but that's not the same thing as saying that you can cure a prospective breach of the Constitution, which is the position before the Court of Appeal, by reference to 36. I'll develop that point in due course. But as I was going to say, the issue of 5 members has now been conceded in the respondent's case, so we can leave it at that. What I was going to do, if I may, is invite Mr. Ram Logan to take you briefly through the factual history, and then I will return with some submissions about Section 110.3. Thank you.
My lords, the unprecedented events which prompted this interpretation claim is one that yields a peculiar context that we feel it's important to draw to the board's attention. Perhaps we can start with page 41 of the electronic bundle, the record, where you will find an undated press release which chronicles the development of the events that led to the appointment of the then Chief Magistrate as a judge of the High Court. You will see at paragraph 4, in April 2016, vacancies were advertised locally and internationally for position of judge for the High Court bench in Trinidad and Tobago. In January to February 2017, there was an assessment process which included a face-to-face interview, a written assessment, review of samples of candidates' written work, submissions by referees, and psychometric testing. In March 2017, 15th of March, successful candidates were informed that they were, of the outcome of the selection process in their favor. Thereafter, we go to the bottom of the page, and you will see on the 9th of April 2017, there was some public disquiet which had seeped into the public domain about the fact that Ms. Ayers Caesar's imminent elevation to the High Court bench had caused some concern. We turn the page over, and in the third paragraph, you will see confirmation that on April 12th, 2017, Ms. Ayers Caesar, notwithstanding the public disquiet on April 9th, 3 days later, she was sworn into office as a judge of the High Court. And at the bottom of the page, you will see, not in chronological sequence, but you will see March 22nd, 2017, it was discovered that some 16 cases had been dismissed. And the Judicial Commission says, without knowing all the details of the matter, they note the unusual nature of this action. It ends by saying she will not be presiding on the magisterial bench whilst the Commission gives further consideration to the matters raised. Now, if we go next to page 37, we will see on April 19th, a press release from the judiciary and its magistrates' court not adversely affected by the elevation of the former chief magistrate. And you will see at the second paragraph, she's described as an industrious officer, and at the third paragraph, the elevation of judicial officer Ayers Caesar in no way adversely impacts the lower court. So this was...
I'm sorry, which page is that, please?
Page 37.
37.
Yes.
This is a press release from the judiciary.
Yes.
Dated the 19th of April.
That's correct, my lady. And it essentially, it's a response to the public disquiet, but it confirms her appointment and says that it has no adverse effect on the state of affairs in the lower courts. We then go to page 39, where you will see a curious press release from the, I don't know if you say judge or chief magistrate, but would have been a judge at the time. Basically, she says she acknowledged concerns raised with respect to the matters that were not completed by her, and as a result of that, she accepts that it would have had an effect on stakeholders in the criminal justice system, victims of crime, the accused, and members of the legal profession, and basically she tenders her resignation. The very same day, on page 40, an almost simultaneous press release is issued by the Honorable Chief Justice. And that press release confirms that the JLSC, in paragraph 2, the Chief Justice is fortified in her renewed commitment to place her duty and responsibility to the administration of justice ahead of her personal interests, and has noted her willingness to attend to those matters. It ends by saying that the JLSC has met and agreed to restore Ms. Ayers Caesar to the magisterial bench. So essentially, it would appear she was resigning her position as a judge on the understanding, it would appear, that she would return, to use the language, be restored to the magistracy, perhaps to complete the outstanding parted matters. All of this is playing itself out in the media, in the public domain, and we're next, on May 8th, you will see at page 82 on May 8th, the pre-action letter in this matter went out. So you have this swirling in the public domain, seeping into the public psyche. You had a near riot in the courts when the parted matters were being called, and the prisoners were being told, defendants were being told that the matters would now have to start de novo. The average waiting time for a murder trial in Trinidad is over 10 years at present. So you can well imagine if your preliminary inquiry has taken anywhere between 5 to 6 years and it's nearing completion, and you're being told it has to be restarted de novo, it's not a matter that you would take lightly, given the presumption of innocence and the fact that it's a non-bailable offense. But be that as it may, it's playing itself out in the public domain, and the next thing we had was the response to the pre-action letter, which you'll find at page 96 of the record. And if we can take it at page 98, it is said that at page 98, it is conceded that the JLSE, as was constituted with 4 members, fell short by 1 member as intended by Section 110. I took that sentence to be an unqualified, unconditional concession by the Commission that Section 110 required 5 members for it to be properly constituted. I thought that was the plain and literal meaning of the sentence. Now, the importance of that, if I take you to page 99 just briefly, you will see that the third paragraph. I submit that a purposive interpretation of Section 110(3)(b) seems to require the appointment of members of the legal profession to provide a different, non-judicial perspective to the JLSE. Nevertheless, there is also no discernible prohibition placed by the Constitution on a former judge filling this category per se. I take you next to June 1st, 2017, which you will see at page 45. And you will see that the next critical milestone was that the Law Association had convened a special meeting, a special general meeting, at which a motion of no confidence was historically passed in the Chief Justice.
Sorry, where do we find that?
You'll find the evidence at page 24. You'll find reference to the date at page 45. Page 24. Page 24, paragraph 6. The appellant says, within the last few months, I've been following the controversy which erupted over the latest round of judicial appointments to the High Court, which culminated in a motion of no confidence being passed by members of the Law Association in the Chief Justice and the members of the JLSE calling upon them to resign. And that is confirmed at page 45. Well, at page 45, it's a letter from the Law Association to the Honorable Chief Justice for giving advance notice of this meeting and inviting him to respond to certain crucial questions about this matter. At page 49, you will see the Chief Justice's response dated May 31st.
Sorry.
Could whoever is making that noise stop it, please? No, it seems to have stopped. Thank you.
Oblige me. So that you will find the Chief Justice's response on page 49. It's dated May 31st, and that's in response to the letter of May 25th. His response comes on the eve of the special general meeting of the Law Association, which was scheduled to take place on June 1st. So it comes the day before. We then go next to page 130 of the record, where you will find a further pre-action letter to the President of the Republic of Trinidad and Tobago. And in that pre-action letter, we say...
No longer the President, I believe.
Sorry, my lady?
The President has changed, I believe.
Yes, that's correct.
Yeah.
We now have our first female President,
You do indeed.
former Justice of Appeal, Madam Justice Paula May Weeks. And at the top of page 131, we requested an undertaking from His Excellency that he will not act on the advice tendered by the Judicial Commission in accordance with Section 104(1) of the Constitution with respect to the proposed or any other judicial appointments pending the hearing and determination of this claim, we asked that he deferred the swearing in of 2 new judges, and we explained why. In the 3rd paragraph, no doubt the process for the appointment of these judges would have started some time ago. As you're aware, the JLSC, by letter dated May 18th, has conceded that it was improperly constituted in that it comprised 4 members, including 2 retired judges, when the Constitution imposed a minimum requirement of at least 5. It is therefore obvious that the process undertaken by the JLSC that would have led to the advice to His Excellency for the appointment of these judges would have occurred during the tenure of an improperly and unconstitutional JLSC with 4 as opposed to the minimum of 5 members that was acting outside of the Constitution, which is the supreme law. His Excellency replies at page 133, and you will note that all of this is taking place on the same day. This was a very busy week. And he said, through his senior legal officer, he says, please be advised that the President acts on the advice of the JLSC in the appointment of judges, and in the circumstances, it would be inappropriate to accede to the request for an undertaking. That is on June 5th. That very same day, having filed the claim in the morning, we were summoned by the High Court to deal with the application for interim urgent relief. And you will find the outcome of that at page 156. At page 156, this was at 2 a.m. in the morning, having been summoned at 4 p.m. in the afternoon. At 2 a.m. in the morning, this was the order that was made, and you'll see it in paragraph 39. Accordingly, the court hereby issues an order that the JLSC forthwith advise His Excellency, the President, to refrain from handing over the 2 successful candidates, to refrain from handing over to the 2 successful candidates any instrument of appointment to the office of judge, and to put on hold the administering of the oath provided for by the Constitution until the returnable date. The judge said he will revisit the matter based on evidence and whether it affects third parties and so forth on that date. So this was the unprecedented factual matrix. The following day, the Court of Appeal convened an emergency session, and the appeal was allowed, and that is why we are here. Now, my lords, I mentioned it's an interpretation claim. I know my lady took it for granted that there is a concession in the respondent's case on the issue of the minimum number of members required to constitute the commission. In the Court of Appeal, there was a sharp divergence of opinion and position on this matter. And I think it's because of the importance of this constitutional issue to Trinidad and Tobago, we would want to invite the board to make a formal declaration with respect to this matter. I say so because in the Court of Appeal, you will see, on the one hand, a Justice of Appeal Rajkumar felt that the Constitution properly interpreted, you don't need to have a minimum of 5. That is Justice of Appeal Rajkumar. He dissented from the majority on this issue, and I can take you to that. You will see that page 213. At page 213, you will see Justice Rajkumar's conclusion. He says, the Judicial and Legal Services Commission would be properly constituted, notwithstanding that it comprised 4 and not 5 members, because Section 110 of the Constitution permits the appointment of 5 members, but does not mandate the appointment of all 5 members. And B, a quorum consists of 3 members. Now, my lady, may I pause to say that...
Mr. Ramlogan, when did the Attorney General concede this point?
The Attorney General never conceded this point. In the Court of Appeal... Oh, sorry,
no.
Beg your pardon.
We now read from his case
yes.
that he concedes the point.
Yes.
And what I meant to ask you was, when did you know that the point was conceded?
When we saw the printed case.
When was that?
4th of October.
Thank you.
I'm obliged, my lord. Now, my lords, what is important for us is that the Attorney General in the Court of Appeal took a completely different position to the Judicial Commission. And you will see that at page 187 of the record. So at page 187, the state, through the Attorney General, this was their position at paragraph 45. Ms. Speak, senior counsel for the appellant, reminded the court that the respondent's case as pleaded had nothing to do with the material composition, numerical composition. She, however, submitted that section 110 of the Constitution did not require the appointment of 5 persons. She argued that 110(2)(c allowed for the appointment of up to 3 persons, but did not require the appointment of the 3 persons. Ms. Haddad for the Law Association supported the construction that the Constitution required that there be 5 members of the JLSE. Mr. Roach for the Judicial Commission was also of that view. I've passed to my learned friend, Mr. Stevens, the transcript of the hearing in the Court of Appeal. Sorry. Oh, I beg your pardon, sorry. It's fair enough. Well, in an effort to avoid passing, in an effort to keep the amount of paper we pass out to my lords, there's just one issue. The office of the President was represented in the Court of Appeal. And the office of the President adopted the submissions made by the state in total. So the point is, on one side, we have Justice of Appeal Rajkumar, the state, and the office of the President, all speaking to the fact that you do not need to have a minimum of 5. And it is significant that the President adopted those submissions because it is the President, ultimately, who is responsible for the formal act of making the appointments. So if they are confused about that matter, we say it is critical that it be clarified once and for all. On the other side, if I take you to page 1, at page 189, you will see Justice of Appeal Mendonça agreed with my submissions, and he indicated at paragraph 52, I therefore agree with the submission that the JLSE should comprise of 5 members. And you will see Justice of Appeal Barrow at page 205. At page 205, paragraph 84, Justice of Appeal Barrow says, in my judgment, paragraph 84, in my judgment, the conjoint effect of 110(2)(c and 110(3) is to require that the Commission must comprise of 5 members. The evidence before us appeared to be that at the time of making the recommendations for the appointment of 2 judges, the Commission was comprised of only 4 members. Now, my lady, I pause here. The position taken by, in respect of this issue, seems to be that because you have a quorum, because you may have 4 members, then you are acting within the law. That misses the mark respectfully. The issue here, a quorum is a meeting concept. It is a meeting concept. So that the issue here for us is, before you can lawfully meet and be quorate, the issue is whether you are properly constituted ab initio. And we say to be properly constituted ab initio, you must satisfy the constitutional prerequisites.
Out of which your 3 can be chosen.
I'm obliged, my lady. Yes. And finally, my lady, on the point of dipping under 4, if you will see attached to our case, we had, well, fair enough. We got some further information pursuant to a Freedom of Information application, which we've attached to the case for the appellant. It simply confirms that for a very prolonged period, they had 4 members. I'm obliged.
My lady, thank you very much. Can I just conclude, if I may, the 5-member point by drawing my lady-in-law's attention to a principle which appears in the supplementary bundle. It's the Hunt case, which will be familiar to several of you. You'll find it at the supplementary bundle. It's Authority Bundle 28, Electronic Bundle 1299. And I'm not going to take you to the head note because it's not material, but I would invite you to turn to the page 2579, Electronic Bundle 1303, paragraph 12, picking it up.
Sorry, you're going to have to help me, I'm afraid.
That's
It's this one.
that one.
Thank you.
It's the
1299.
Thank you.
yeah. And if you could turn through, please, to 1303.
Can you give paragraph numbers? 'Cause
Yeah,
the-
it's paragraph 12. Sorry, I did
Thanks.
say 12.
It is just that the electronic numbers on the supplemental bundle are not the same.
Oh, I'm so sorry.
It's all right, don't worry.
No, they haven't been put together, and so the numbers haven't carried on, and so we've got a separate supplemental bundle which is from 1 to 49.
Oh.
Just to make your life really, really easy.
Thank you. Well, anything that makes my life easier increases the pleasure.
I'm being
It's
ironical.
33.
I thought you might be.
33.
Can I just take you to the passage that I...
Oh, yes, I see.
May I take you to the passage? If we could look at the page at 1303, just around D, where the Supreme Court say, however, in circumstances where a public body has acted unlawfully, but where it is not appropriate to make a mandatory, prohibitory, or quashing order, it will usually be appropriate to make some form of declaratory relief to reflect the court's finding. And it goes on to words to that effect. It's also a case about costs, which I needn't trouble you with. But the reason I draw attention to is it's consistent with saying in a case which has a public interest, which this case has, where there are serious differences between the party and an important division of opinion by the Trinidad Court of Appeal, that it would be sensible to invite the board to make a declaration in order that the issue is resolved definitively. Can I next move on to the legislative history, just to make a very short point? I'm going to rely on the legislative history as it appears in our case, and I don't propose to advance additional submissions about that, save in one respect. You'll find the history begins at paragraph 12, page 5 of our case. And as a result of the research, can I make two separate points? We have put a lot of time and effort into trying to identify the legislative history for this somewhat curious provision. And we haven't been wholly successful. But the material we cite here. Due to the efforts of the board, we need to amend. Pardon me? Oh, this is from the respondent. I was referring to the draft, which I have. Is that from the respondent? Oh, I'm so sorry. It's from the respondent. It's my fault. We now have a further document, which I've seen this morning. So we need to make an amendment to paragraph 16 of the case. If I could just ask you to do that. You'll see presently it says it's a government draft. That is incorrect. This is the corresponding clause that we're looking at here was one that emerged from the select committee. And I'll be coming to this in a minute.
So this is the select committee's draft, isn't it?
Yes, it is. That's the one that I've seen today. There are 2 points I want to make in addition to that.
It's not, with respect.
Oh, I'm so sorry. I'm sorry. It's my fault. Right. Sorry. It's my fault entirely. I am sorry. The position is that the draft that I've seen today means that we have to make the correction that I've just stated.
So what is the correction, please, Mr.
It is that this is the draft that emerged from the select committee.
The corresponding clause of the delete government draft insert that emerged from the select committee.
Precisely so. I am very sorry to make a meal of that. Can I make two additional points of just about this draft, which we'll look at in the moment. We don't need to look at the draft itself. But what this draft basically is the same as the 19... Right, okay.
We've just been handed a draft, this one.
Yeah.
Is this the Select Committee's draft?
Yes,
or
it is.
government?
If you
This
turn
is
to
the Select
page...
Committee, so should we write on that?
It's not.
It's not.
I'm so sorry.
why
Can we
Mr.
just leave the
Stevens-
amendment?
Let Mr. Stevens
Stevens
tell
tell
us
us,
what
yeah.
the position is.
Right, okay.
My lady, when we read paragraphs 15 and 16 of my learned friend's case, we saw reference first to the government's own draft, which was laid before Parliament, effectively at the white paper stage, reference to a joint select committee being set up to consider it, and then in paragraph 16, the assertion that the only difference between section 110 as enacted and the corresponding clause of the government draft was that, and then there's a very minor difference which is alluded to, which was the result of debate in the Senate. Now, we asked for the government draft that was being referred to, and the appellants weren't able to provide us with that, and therefore we made inquiries of our client, and what my learned friend has been given this morning is what we understand to be the government draft. So that's the document that he's referring to. It's right also that the Select Committee report, which we have, refers to a revised draft, which is said to be appended to it. We've asked my learned friend for that, and they haven't been able to provide that either, and we have not been able to obtain that. So we appear to have the government draft.
This is the government draft,
Not the Select Committee.
not the Select Committee.
Not the Select Committee draft.
And so was paragraph 16 correct then?
Well,
Or-
we think not with respect in the terms that it's drafted, because what it suggests is that there was only a minor difference between section 110 as enacted, and you've obviously seen what that says, and the corresponding clause of the government draft. If my lady turns to section 119 of the draft that you've got in front of you, you'll see an altogether different clause relating to the Commission. It's internal page 59, and you'll see in particular that subparagraph 3, A and B, are in completely different terms. So I accept that paragraph 16 in my learned friend's case needs correction. We still don't have the revised draft which the Joint Select Committee appended to its report. We have its report, but we do not have their revised draft, and we have asked for that, and we have not been able to obtain that. Additionally, and finally, at the bottom of paragraph 16 of my learned friend's case, it refers to Hansard, specifically the 26th of March 1976, and a page reference is given, page 899. That is not in the materials. We've asked for it, and we've not been provided with it. It's unclear to us how my learned friend was able to refer to it in his case, bearing in mind that we haven't got it. My lady, that's as far as I can take it. We've been able to provide what we believe to be the government draft. We're missing the revised draft appended to the Select Committee report, and we're missing the 26th of March 1976 extract from Hansard.
Thank you very much, Mr. Stevens. The position essentially is this, is that the draft which you now have before you is in fact the same as the old constitution which I was about to look at. So you don't really need to waste time looking at this one now because it's the old version. As to the position about what emerged when the Senate amended, you can see that from page 712, which I won't take you to, which is the Senate version, because they actually say what the amendment is, unsurprisingly. It's basically the speech promoting the amendment. And as far as the House of Representatives is concerned, although there may be some question whether we ask for it, we will be producing that in the shorter term. I'm very sorry about the legislative history. In fact, it is a disproportionate activity because it doesn't cast a great deal of light onto what Section 110 does. What I would like to do, if I may, having fallen at the first hurdle, is to look at the speaking note, which sets out, I hope relatively crisply, our submissions. Turn to that, please. Now, the first point I want to look at, which you'll find at A2, electronic model 372, is the old Constitution. 327, I'm sorry. I am definitely dyslexic. 327, if you could turn that, please. Section 83. This is the 1962 version of the Constitution. And I'd invite you to read it, and you'll immediately see it's very different in character from Section 110, which you'll have read before. And I want to just make 2 points about it once you've had the opportunity to read it.
Well, that seems to be the same as the...
It's the same as the one, that's what I was trying to say, albeit it took me a long run at the wicket. The 2 points I want to make are these ones. Subsection 2D, which you'll see at 328, refers to 2 members which are appointed in accordance with the provisions in subsection 3. And there are 2 points about that I want to draw attention to. The first is at 3A, that one such person shall not be qualified unless they're a judge. So that's a qualification requirement. And I make the point about it being a qualification requirement because the language is completely different in Section 110, which we'll turn to. And the second point I want to draw attention to is that subject to the qualification required under 3A, the second person can be anyone. Can be a non-lawyer, person of eminence, or so on. So he certainly doesn't have to be a judge. If I could next move to the submissions which we make in relation to Section 110. This is the second page of the speaking note. If you turn to page 325 in the electronic bundle, you'll see Section 110. And you've obviously had the opportunity to look at this before. And the first point I want to make, paragraph 2 of this speaking note, relates to subsection 2C. If you could turn to that. That appears at page 325. The members of the Commission shall be such members as may be appointed in accordance with subsection 3. The word may, in fact, must be read as shall, because subsection 3 is mandatory in terms of the requirements it prescribes. So may means shall in that context.
Well, I think the prefatory words import that. Members of the committee shall be, and then you have to take that down to see such other members as may be appointed in accordance with subsection 1.
Yes, with respect, I agree. That's entirely right. Can I next go to subsection 3? And going back to our speaking note, if we look at subsection 3, you'll see the first line of A and the first line of B have the word among. And we submit or say that the fact that the word among is used twice suggests we're talking of 2 different categories of members. And we contend, or at least one of our contentions is that they're mutually exclusive. You either come in the category A or category B. But we also point out, and this is important in relation to the submission I just made to the old Constitution, Section 83, is unlike the qualification, which was, if you'll remember, the qualification to be a High Court judge under the old Constitution, this in our submission, unlike the position in respect of the Commission under the old legislation, which was a qualification, the subsections A and B create two different pools. They're pools of candidates. You're choosing amongst pools. And then the way the subsections work is you define the pool and then you specify a number. 1 in respect of A, 2 in respect of B. The next point we draw attention to is that we point out that Section 100, this is paragraph 4 of the speaking note, Section 110.3a indicates that the pool is from among persons who hold or have held the office as a judge, one shall be appointed. And we emphasize that if that were a standout provision, a standalone provision, the position could hardly be clearer. You can't have under Section 110.3 more than one. So Section 103A, under A. So what does one then make of B, which is, we respectfully acknowledge, a much more broadly framed provision? And we do accept, but in our submission as a matter of construction, it doesn't work, that it would be possible, given the breadth of the pool in 3A, which is two from among persons with legal qualifications, at least one of whom is not in active practice, it would be possible to shoehorn a judge into that second category B, although we will submit for various reasons that that would be the wrong approach.
But so far as the text of the provision is concerned, it would be theoretically possible to be, how shall I put it, an inhabitant of both pools.
That's right, in principle. I mean, I'm going to try and not jump ahead because it's rather complicated, unfortunately. Can I get to the end? And
absolutely.
I haven't found this entirely straightforward, speaking for myself. The next point we want to make is that subsection B, this is paragraph 6, is not to be read in isolation, but should be read as being subject to the earlier subprovision A in the same section. And that subsection in our submission takes precedence in accordance with the rule of construction that special provisions override general ones. We give a reference to Lord Cook, but it's helpful to look at the case of Cusack. In fact, the reference is in the weekly law report, which I think is the one we've got. But that...
Why is one of these provisions to be regarded as general and the other as special?
Well, it's a matter, because we say that A deals specifically with judges, and importantly, a submission I will make in a moment, defines judges as post holders, which is quite an important concept in public law terms. That's what A says. It defines a category as post holders. The second B refers to persons who have legal qualifications, which of course is not, amongst other things, the same as someone who's admitted to practice, which is quite separate. It's a very large pool. And the submission I'll be advancing, and we concede you can shoehorn them in, but I want to just look at Cusack because that deals at some length with the principle of the special takes precedence over the general in terms which I hope will assist the board in terms of evaluating this particular submission. It's quite a detailed account of it, and it's to be found at Authorities Bundle 7, page in the electronic bundle 379. If I could just briefly take you to the head note, if you have it. The claimant basically had a forecourt with which vehicles could access from the highway. He used the property as an office in breach of planning control orders, and in 2002, the council, as the highway authority, notified him that it wanted to erect bollards to prevent vehicles from crossing the footway outside his property. The claimant sought an injunction in the county court restraining the council from putting up the proposed barriers. In its defense, the council pleaded that driving cars over the footway endangered the safety of road users and relied primarily on Section 80, alternatively Section 66 of the Highways Act 1980, as conferring the necessary power for the works in question. Section 80 entitles the work to be undertaken without paying compensation, whereas Section 66 requires the payment of compensation. That's relevant from the approach that the claimant contended for. There was also an Article 1 protocol at one point, which I needn't trouble you with. And if you could ask you to go to the bottom, the judge in the county court refused to grant an injunction. The very last line of this page, the Court of Appeal allowed the claimant's appeal on the basis that the proposed works fell squarely within Section 66, and therefore applying the principle of statutory construction that specific overrides the general powers, the council was only entitled to proceed under Section 66. Allowing the appeal, the Supreme Court held that Sections 66 and 80 of the 1980 Act were different provisions concerned with overlapping aims and applications, and on a natural meaning, the Council was entitled to rely on Section 80, which contained no express or implied restrictions on its use for the powers it sought. And the fact that Section 66(2) might confer an alternative power to achieve the same object, which was subject to compensation, was immaterial. That was the holding. And if I could ask you to turn through, please, to page 383 of the bundle. It's just here we can see the provisions. Paragraph 6 at 383 sets out Section 66. And it's subsection 2, which is relevant here. And then you'll see, if you turn the page to 384, subsection 8 states that the authority shall pay compensation. And then we then see Section 80, which is set out in paragraph 7. Now, the approach of the Court of Appeal, this is relevant in terms of the submission which will follow, accepted the submission for the claimant that viewed in the context of the structure of the whole, this is paragraph 9, Lord Justice Lewisham found, that this is at letter H on page 384, Section 66(2) applies where the Highways Authority consider the erection of posts as necessary for the purpose of safeguarding persons. This is a much more specific reason for invoking a statutory power than the more nebulous statement of purpose in Section 80. Indeed, it's precisely the reason, according to the Council, it wished to erect the barriers.
Mr. Clayton, obviously we've been reading ahead to some extent.
Yeah.
Correct me if I'm wrong, but both the substantive judgments say that the principle, general specific distinction, has no application to this case.
To the case they were considering. Yeah, precisely, it says that they do.
How much help are we going to get from it on the principle?
It's on the principle, but this difference between the two, there's several bits of the case which assist your lordships and ladyships. The first is that essentially the overlapping provisions holding is based on looking at a consolidated legislation with different histories. So the context is very, very different from looking at a single statutory provision where we would submit that the legislative drafter and Parliament in enacting it would have a closer sense of how the two should be appreciated one against the other. The other element to the case, and this is picked up particularly by Lord Neuberger, which I can either come to or not if your lordships read the case. I mean, it's a case which your lordships will want to read for the purposes of the submission, obviously, is that principles are not, our servants are not our masters, and one has to look carefully at the statutory context to see whether a particular principle has application in any given case. I mean, if I could summarize the authority in that way, I mean, that is really the principle that emerge from it. If that's sufficient for current purposes, I'm content to move on. I make these points at paragraph 6 of the speaking note that essentially there's a contrast to be drawn between, this is 6.1, provisions with different histories and consolidated legislation on the one hand, and a single statutory provision or constitutional provision, strictly speaking, where one assumes and construes it on the basis that it is to be seen as a whole. So,
is it paragraph 57 of the judgment that you wanted us to go to?
Bear with me. Yes, it was, 57, it's really from 57 on to about just 61 that I was going to take you to.
So this is an example of the canon of construction not applying,
yes,
that you want us to cross-apply to make it apply in the current case.
Well, I wouldn't quite put it like that. I mean, what I would say is that what it shows is how these principles are to be applied. And the important point to make about this case is this case was concerned with, albeit two provisions in the same act, it's consolidating statute and it's wholly different histories. So it's unsurprising, really, is one of the points that's made, that there's going to be a conflict. There's no reason to construe it in a particular fashion as the Court of Appeal did. That's really the conclusion that the Supreme Court reached. And all I'm saying, but with respect, we would submit it's a point of some importance, is looking at different provisions in a consolidating act is very different from looking at two provisions side by side in the same provision. In the same section, yeah, same section. So we say that that's an important starting point in terms of considering the application of the principle. Yeah, no, I know that. We also, as I've said, I've already made the submission, I think, A draws a distinction between office holders on the one hand, and B is those with legal qualifications. We next at paragraph 8 point out that legal qualifications are different from a person qualified to practice at the bar. It's much wider. It's quite important to appreciate that. It would, for example, encompass the possibility of an academic or a captain of industry with a law degree being a member of the commission. So it is broad in scope, although I accept that's not decisive in terms of how you construe it.
Are legal qualifications defined in the...
They are. They're defined. I mean, we haven't brought all of that. It's to be found again in the supplementary bundle. It's to be found in the Legal Professions Act. That's tab 27, 1275. It's a short bundle.
That's page 5.
Right, okay. I've been reminded that this describes eligibility for call and describes the members of the bar in Trinidad. That's as close as we get to what the conditions for admission to the bar, and indeed its solicitors are.
But it doesn't define legal qualifications.
Uh,
Arguably, the acquisition of a law degree does not necessarily endow you with a legal qualification.
No, with respect, that is our submission, precisely. And it may be that the closest we get to with the 2006 Act is a description of the conditions which have to be satisfied to be admitted to the bar or on the roll as an attorney in Trinidad.
Yeah, but I'm
But
sorry.
my Lord,
I'd understood your argument at paragraph 8 of your speaking note to be that legal qualifications opened up the field to anyone with a law degree. And I'm just posing a query as to whether that is right.
no, sorry. What we're saying, it may be the infelicity of language. What we're saying is that legal qualifications is more general than a practitioner, because there are additional requirements that someone would
A
have.
practitioner has to be a Commonwealth citizen, has to be of good character,
Has to go through certain educational.
in addition to holding the qualifications prescribed by law.
Exactly.
So you're saying there are additional things that hoops you have to surmount, go through?
Yes, satisfied.
In order to qualify as an attorney, but you could have legal qualifications. This is section 15.1c of the Legal Profession Act, without actually being able to practice.
Yes, precisely. That is
That's
that's the submission. That's
But
excellent.
you have got a slight difficulty because of the words of B, 3B. The words as such. You haven't got to be in active practice as such. It must refer back to something, and the only thing it can refer back to is a person with legal qualifications.
Well, that's true, but just if I can just unpack that for a moment. In fact, actually, we deal with it, I think.
Don't let me take you out of your course.
No, but I'll try and deal with that now. It's one person has to not be in active practice. It could be two, but not less than one. So that's the first thing to note about it. The second is, although it's fair to say, as my lady says, that one person shouldn't be in active practice, it therefore incorporates the possibility that they may or may not be a practitioner. But the fundamental point remains the submission which I've just made, is that all you need to have is legal qualifications.
Yes, I'm afraid that doesn't really address the point, because the as such must refer back to something, and it is the pool that it has to refer back to. So it means more than certainly means more than having a law degree, I think.
Well,
you wouldn't be in active practice as somebody with a law degree.
Well, I don't know. I mean, it could be an avoidance of doubt of question about how active does someone have to be in active practice. If someone is, for example, an academic and derives a substantial part of their income from that, but practices occasionally in part-time, that may not qualify for active practice as such. Certainly, I don't accept with respect, that as such qualifies legal qualification to the extent that it means or converts it into a practitioner. I don't accept that. I mean, I have to say, although for what it's worth, this constitution is essentially derived from the Constitution of Jamaica, but although one can see the history of it, it's not easy to discern what it's intended to achieve. And I accept entirely that it's difficult to construe. But what I certainly we say is that as such doesn't restrict the word legal qualifications to practitioners. It can't do
Mr.
that.
Clayton, I'm sure it's my fault. There's been this discussion about whether a law degree counts. Are you saying that somebody with a mere law degree from a university has legal qualifications?
Well, in our submission, it's legal qualifications is certainly something different from being qualified to practice. It's not the same. So we would submit that someone could say of themselves they have legal qualifications if they have an LLB or a BCL.
I see. Very well.
Could say that. I mean, it's...
Thank you.
Thank you.
How does that help?
Well, what that suggests is the pool is wider than simply practitioners. I mean, it may be that.
So it could include judges.
We've accepted that. We accept that as a matter of analysis, you can always shoehorn judges in.
Oh, you accept it, but with the word shoehorn, which is obviously a pejorative term.
Well, all right. I mean, I'm not going to argue about the extent of the concession. I mean, realistically, the category is defined in a way which you can arrive at that outcome. We accept that. However, what we do submit, and I have additional submissions to make in a moment, that if you construe the two provisions together, you don't end up with that result.
Well, you don't have to go so far as to say that someone who's acquired a law degree is someone possessed of legal qualifications. You can make the submission, can you not, that the group is obviously wider than someone who has been in legal practice or who is currently in legal practice, because it's perfectly possible to acquire a legal qualification without practicing.
Yes. My Lord has expressed the point more elegantly.
No.
But that's really what I was struggling to say. That is the submission, yes.
So when we wonder what qualifications means, we note that on the next line there's a reference to practice.
Yeah.
Doesn't that rather indicate, Mr. Clayton, that when qualifications are talking about qualifications to practice, but of course you may have a qualification to practice, but not be in active practice?
I accept that is one construction of it. I mean, I will be coming to an additional point,
Very well.
which I hope is an answer to that.
Thank you.
Thank you very much. The next point I want to make is at paragraph 10, and this is really looking again at the language used in A and B, being rather different one from the other. We would point out that a judge isn't a practitioner. Indeed, he's expressly defined as an office holder in A. And the idea that a judge is returning to practice by giving up his office is a slightly odd one. That's the first thing to say. And secondly, whatever the position might be in 2018, that certainly wasn't the position when this Constitution was drafted in 1976. Because in 1976, judges were thought to be people who couldn't be in practice at all. So if I may go back to the point made by my Lady Green, it may be that the active practice in the way that she approached it actually serves to demonstrate that judges don't come within this category.
Well, that was really what I was thinking, that by widening the category of B, you were not assisting yourself. If you narrowed it to practitioners, you would be.
Well, that may be, I'm afraid it won't be the first time that I didn't put my best foot forward. But I mean, that may well be right. But and I accept that. But I would respectfully, we would also submit that the point we just made at paragraph 10 rather supports the suggestion that has just been advanced, that judges are something different because they are office holders. I don't know whether it's necessary, because of time, to take you to the speech of of that Lord Chief. But it's at EB 289. Is that right? No, it's not, is it? But that is not that. But that's the wrong reference for it. My learned junior can find it for me. But basically, what happened is that a judge in 1981 returned to practice, and that created considerable controversy. One can remember the position in England, similar sort of situation. And what actually happened, and the speech refers to this, is the Bar Council thought that was a bad thing, And this is all referred to in the speech. And there was a meeting of the Law Association, very few people attended, and they didn't think it was a bad thing. And the Lord Chief's speech, which was given at the beginning of the law term, was deprecating the state of affairs which we'd ended up with, where this level of uncertainty arises. The correct reference is EB 661. But what that definitely shows with respect is that whatever the position might have been when the Court of Appeal were seized of the appeal, judges were not entitled to practice in 1976, which is the relevant date for the purpose of construing the Constitution. That's paragraph 10. Paragraph 11 of the speaking note points to a potential ambiguity which arises from the suggestion that judges can be appointed under paragraph B. I'm going to call paragraph B as the legal qualifications paragraph. The question that arises really is, do you end up with 4 rather than 5 on that basis? And the reason you say that is a judge appointed under B also a judge appointed under A? A is 4 judges, no question at all about that. But if you appoint judges under B, then you could say, well, the 2 judges under B, one of them is also the judge under A. So you end up with a total of 4 rather than 5. I hope I've expressed that clearly. And that's a very odd outcome. Because in other words, what I'm saying is if there's an overlap between A and B, then it may be sufficient to say 2 people have been appointed out to B, they're both judges, so one of the 2 under B is also the judge under A, so you end up with 4. And that's a very...
You might say that in practice is what was the case for quite a lot of time.
Well, that may be so, and that's another reason, if I may say so, my lady, why the declaration which you referred to at the outset is of some importance. But of course, as we go on to say at paragraph 12, the position is this ambiguity provided some assistance to the respondents below because they were trying to argue 4 rather than 5, or 4 would do rather than 5. That's now been abandoned. But the ambiguity inherent in the view that 2 judges could be appointed under B still is there. And that's another construction issue we rely on. Then the next point I want to make is that there are sound reasons, this is paragraph 13, why judicial appointment commissioners should include non-judicial members. My lords will have seen in the papers, I'm not going to take you to them now, they're well rehearsed, and we of course in this country, the Judicial Appointments Commission has a large number of non-lawyers on it. And some of the material we have indicates precisely why. And indeed, I've quoted here from the Bingham Center report, which is a sort of most authoritative discussion of judicial commissions. It's in the bundle. You'll see from the number, at least half the commissions in the Commonwealth countries contain both academics and practitioners. But more than that, and here there's a link, if I may say so, between the position that Mr. Ram Logan outlined at the beginning and why this perhaps somewhat arid issue of construction matters. In our submission, what basically happened here in relation to the Chief Magistrate's appointment is it transpired that her case management skills were not all that she said they were. They had no practitioners on the commission. It may well be that if the process has been leavened by the insights of practitioners, they would have been less surprised that her appointment resulted in what's quoted, I think from the Judicial Commission press statement, as a sustained chorus of protest. I mean, there is a danger, if I may say so, of which this case, some might say, exemplifies, that judges don't necessarily have the ear to the ground of what's happening in practice. And here that seems to have been the position. So that's a policy matter which you, my lords, and ladies, can take as far as you like it to, but it is one which in the context of this case, in our submission, has some force.
Well, first of all, there's a certain amount of ex post facto rationalisation in this argument, is there not? I mean, the Constitution is dated 1975.
Sure.
Much of the current thinking about the composition of Judicial Appointments Commission is of lesser vintage than that.
Sure.
Yeah. The second point, of course, is that Section 110(3)(b) specifies that two from among persons with legal qualifications, at least one of whom is not an act of practice. So it clearly contemplates that both of them would not be an act of practice. And
yes,
if they're not an act of practice, the question of whether their ear is any closer to the ground than the judiciary is called into question.
Well, as with many submissions, one can take it in many different ways.
Yeah.
But the point is, and this is not an unimportant factual observation, is the catalyst to all of this was the appointment of someone who described her case management skills. My lords will know this is regarded even in this country as an important attribute for prospective judges. It's on the Judicial Appointments Commission criteria, one of them. And it was assessed by people, all of whom were judges. And it's particularly striking in a small community, which Trinidad is. And all we're saying, and I can't make the point I entirely accept my point made by Lord Kerr that this is the question of non-judicial members of a Judicial Appointments Commission is a theme which has developed more force over time. I accept that. But nevertheless, I'm just making a practical point about how that may have had an impact on where we are here. And then, if I can make the last point on the speaking note, which is paragraph 15, we do have an alternative submission to the submission that A and B are to be treated as mutually exclusive. And it's really to this effect, that they define pools. A defines, this is 15.1, A defines a pool of judges as comprising one judge only. And therefore, we submit that A mandates the Commission to have a single judge, regardless, and contrary to our submissions, whether judges can be selected under 110(3)(b, or the Commission only comprises 4 members. In other words, our submission, this submission is that subsection A means what it says. You can have one judge and one judge alone. So it basically, on this analysis, provides a judge quota, that's A, and then a legal qualifications quota, that's B. There are different pools and different quotas. And if I could illustrate this submission by an analogy, imagine, if I may, if you would, I asked my son Jack to go to the supermarket with instructions to buy one product in the vegetable aisle and 2 products that are orange. So one's from the vegetables and the other is just 2 orange products. If Jack returns with 3 carrots, we would submit he hasn't complied with these instructions. There may be room for argument as to whether the 2 orange items are in addition to the item from the vegetable aisle, or whether a carrot can count as 2 items, but the instructions were to buy 1 vegetable. And we say that analogy is of assistance in looking at what A means. A means what it says, 1 judge. Like most construction issues, there is, I'm afraid, a limit even what I can say about it. So unless there are any matters that I can assist on the construction issue, I'd like to go to section 36.
Mm-hmm. Yes, by all means.
Thank you very much. Just if you would bear with me for a moment. Before I make this, the submissions I'm going to make, I'm going to draw from our case. So I'm really working from page 12 of our case onwards, paragraph 31. And this submission is solely directed to the question of whether the courts, and in what circumstances the courts are entitled to rely on Section 36 of the Interpretation Act. And there are 2 points in our submission importance to recognize. The first is the approach of the Court of Appeal was to say that in relation to a prospective breach of the Constitution, Section 36 was a get-out. In our submission, that's wrong in principle. The second point we make is that our researchers, and the other side have no comments to make on this, are that Section 36 has never been invoked by a court before, in Trinidad or anywhere else. So it's the proper limits of Section 36 is quite an important legal question, particularly given the context in which it was deployed in this case. So what I want to do is look at the predecessor to Section 36 and then Section 36, and I'll find Section 36 is at 336. Can you find that?
Page 336.
Yeah, sorry, can I just ask you to keep that open and then look at the supplementary bundle just to look at the predecessor? I'm sorry, it should have been in the original. It's at 1273. Or page 3 electronic, I'm told. If you're looking at the old version of the Interpretation Act, first of all, Section 37, do you have that?
Yes.
Section 37 says, where by or under any enactment passed, a statutory board is established, and subject to any requirement of that enactment with respect to the quorum, the functions of the statutory board are not affected by any vacancy. So the focus of that is on functions. That is very different from Section 37, if I can ask you to go back to, sorry, Section 36, forgive me. 36 appears at 336. Do you have that? This is the current section of the Interpretation Act.
Yep.
And you'll see the side note, which I'm going to return to because that's quite important in our submission, which says that defects invalidate acts done in good faith. Defects not to invalidate acts done in good faith. I am so sorry. Bad eyesight. The point I want to make is that 36 covers D, any vacancy in its membership, and it basically, so it includes this possibility. It says, where the board is established under a written law, subject to any requirement to a quorum, the validity of any act done in pursuance of any power of the board shall not be affected. So in our submission, 2 things. One, what subsection 1 is designed to do is to restrict the relief that could be granted for breaches, because you can't challenge the validity. So you couldn't quash a decision, but you could make a declaration. And there's a further point to be got from the side note, which shows that it has to be, it doesn't invalidate where people are acting in good faith. But with great respect to the Court of Appeal, and I'll come to the status of side notes in a minute, assuming that it's relevant, which it is, with great respect to the Court of Appeal, when you're dealing with a prospective breach of the Constitution, you can't, with respect, apply Section 36 by saying, which is designed to deal with defects in good faith. Everyone knows what the breach is, and the question is what to do about it. I wonder whether I should just briefly take you to the leading case on side notes, because it is an aid to construing the effect of what Section 36 states. If you could again go back to the supplementary bundle, it's the last authority. It's tab 29, should be at 1306.
Well, before I looked, I said this has got to be Montilla.
I somehow got, well,
It's Montilla, isn't it? Yeah.
It is Montilla, yes. It is. Now, I may be able to take this very quickly indeed. But basically, one of the issues that arose in Montilla was what was the status of a side note. And interestingly, counsel on both sides seemed to take the view that it didn't really assist very much, and the House of Lords held otherwise. And what's important to see is that the holding, which appears at in the head note, which I hope you'll see, what for me is everywhere stated 1306. Do you have that? Page 36, electronic, I'm told. So sorry. Do you have that? And it says, sidings held, headings and side notes are as much part of the context of an act as explanatory notes, which goes back to a speech of Lord Steyn in a Westminster case about 2 years before, which are admissible aids to construction, and there's no logical reason why they should be treated differently, that the account had to be taken of the fact that the headings and side notes were included in a bill, not for debate, but for ease of reference, which indicated that less weight could be attached to parts of the act which were open to consideration and debate, but they were nevertheless effectively relevant. And really, I derive from that, and that applies equally in Trinidad, the position is that the head note shows effectively what the function of Section 36 of the interpretation.
Well, it's paragraphs 32 to 36 of
yeah, it is.
Lord Hope's speech, isn't it?
It is. It's precisely so. And in that speech, he refers particularly to 35 to Pickstone and Freeman, and to the Westminster and Nass case, which is the one I was referring to, Lord Steyn, when he talked about explanatory notes. So I'm not saying it's determinative, but it is an aid to construction. And so far as it is an aid to construction is concerned, it does suggest that you can't deal with a prospective breach of the Constitution, as the Court of Appeal thought, by recourse to Section 36. That's the first solution.
Can we make absolutely clear what defect we are talking about when you make your Section 36 submissions? I think you're talking about 4 members rather than 5. Yes. I think you're not talking about the absence of a practitioner. No, precisely. I am so sorry.
Very well. My lord is right. It's because sequentially the issue's gone, but that's what it was designed principally to deal with. The next point I want to make about the importance of Section 36 and its limited scope, you'll pick up at paragraph 33.1 of our case, which I'm sure I don't need to take my lords to it, but it's worth emphasizing Section 2 of the Constitution, that under Trinidad law, Section 2 makes the Constitution supreme law. And it's a very odd thing to suggest that you can breach the Constitution prospectively and somehow Section 36 is sufficient. In our submission, although I hesitate to use a very overworked phrase, what we're here concerned with when we're dealing about whether you can rely on Section 36 is a rule of law principle. And in that context, I would, with respect, draw attention to the recent Trinidadian decision of the board involving the Lord Chief Justice, which I think we'll find at EB 340. Tab is that? Yeah, it's 5. It's tab 5. So if I could ask, it's a decision of my Lady Hale, and it's at 340 of the electronic bundle, if you have that.
I believe it was a decision of the board which was voiced by me.
I'm so sorry. Right. I'm looking at the transcript, so. But if I can just draw attention to paragraph 1 firstly, just to set out the context. The appellant was the Chief Justice. There were a series of press articles making allegations against him. The respondent was a law association. They resolved to set up a committee to inquire into the allegations. Under Section 137 of the Constitution, the Prime Minister is the only person who could advise the President to initiate a formal inquiry. And it was said on behalf of the Chief Justice, effectively, that because of the Section 137 procedure, it was none of the business of the Law Association. If I could just take you quickly through to paragraph 18, page 344. Again, this is part of the judgment. A vital element in any modern democratic constitution is the independence of the judiciary from other arms of government, the executive and the legislature. This is crucial in maintaining the rule of law. Judges must be free to interpret and apply the law in accordance with their judicial oaths, not only in disputes between private persons, but also in disputes between private persons and the state. The state, in the shape of the executive, is as much subject to the rule of law as are private persons. An important part of the judicial task in a constitutional democracy is not only to ensure that public authorities act within their powers, but also to enforce the fundamental rights of individuals against the state. Judicial independence is secured in a number of ways, but principally by providing for security of tenure. In particular, this requires the judge may only be removed from office or otherwise penalized for inability or misbehavior, and not because the government does not like the decision from which he or she makes it. And that it should also be followed by a fair procedure. Now, I accept that obviously is expressed in the context of the removal of a judge, but in our respectful submission, things that touch upon the appointment of the judge likewise involve issues of the rule of law. And in our submission, the court should be slow to look at a section such as Section 36 to say that defects in the Constitution can be put to one side. That's the submission. We also make subparagraph 33.3, page 13, we further draw attention to what actually Section 36 focuses on. It only seeks to preserve the validity of an act done pursuant to a power in certain circumstances, and this is important with respect to because it's contrary to the approach the Court of Appeal took. It does not purport to modify any legal requirement as to the composition of the board or release any person from any obligations in respect of the composition of the board. And in our submission, Section 36 exclusive, this is 33.4, turning the next page of the printed case. Section 36 focuses exclusively on remedies and is confined to prohibiting a court from invalidating defects made in good faith by making an order of certiorari. In our submission, that's the function it's designed to serve.
Do you accept that it does perform that function in relation to Section 110 of the Constitution?
Well, not in the context of this case.
Well, In general.
In general, yes.
So that if there's a case where validity of an act of the Commission is an issue,
Yes.
you do accept
Yes.
that it can be validated
Yes, I do.
by Section 36. Thank you.
Yeah, I mean, what I think the essence of our submission is really this, is that Section 36 focuses on remedies, particularly, and we don't have cavil with that as a proposition.
Your point is that it can't operate prospectively.
Precisely so.
And that in the circumstances of this case, that's all that arises.
Exactly. But it's important, we would submit, that the proper limits of Section 36 are acknowledged, otherwise it can lead to unsatisfactory outcomes.
Well, you can't ignore the way in which this case developed, Mr. Clayton,
No.
which was you asking for an interim injunction at
Yeah.
night that two women be not appointed to the High Court bench.
Yes.
And you got a remedy in respect of that,
Yes.
notwithstanding Section 36.
Well, can I just have a...
Of course.
Well, what I'm not sure this helps. They weren't then appointed. I mean, I do accept that. I mean, that's certainly a proper answer. But the whole way, if one looks at the facts as they unfolded overall, perhaps one could sort of say these things sometimes seem to happen in Trinidad. But it certainly developed a momentum of its own. And really, where we do draw the line was the point just made by my Lord Lloyd Jones, to the effect that whatever the scope there is for Section 36, it's not designed for prospective breaches.
But your main point is that it can't apply to breaches of the Constitution because the Constitution is the supreme law.
Yeah,
And anything that's inconsistent with it isn't valid.
yeah. That's also so.
That's your main point.
Yeah, it is, yeah. Thank you. I'm not sure that I need... We then all go on to make a point which your lordships can find in the authorities if you wish to see it, at paragraph 36, which is to the effect that if there are issues about vacancies, that was an issue which was considered in the South African case, but that isn't really the kind of position we're in here. That's quite a complicated case, but I can leave you to look at that at your leisure if you wish.
It's very good of you.
But, yes, very different. I agree. So someone does the best one can with the material. My lords, unless there's anything else, those are our submissions.
Nothing from us, I think.
Thank you very much.
Mr. Ramlogan, you've had your say. Do you want another one? Thank you. Mr. Stephen.
My ladies, my lords, I'm going to start with the section 110.3b issue, if I may. And to state, well, at the risk of stating the obvious, the starting point is obviously the words themselves. And if authority for that proposition is needed, it's to be found in the dictum of Lord Reed in the case of Pinner. There's only a very short passage of relevance. It's tab 11, electronic page 515. At page 517, letter C. In determining the meaning of any word or phrase in a statute, the first question to ask always is what is the natural or ordinary meaning of that word or phrase in its context in the statute. It is only when that meaning leads to some result which cannot reasonably be supposed to have been the intention of the legislature that it is proper to look for some other possible meaning of the word or phrase. We have been warned again and again that it is wrong and dangerous to proceed by substituting some other words for the words of the statute. Furthermore, my lady, there is, in my submission, a presumption in favour of the grammatical meaning, in other words, the meaning conveyed in a phrase or sentence by word order and other grammatical pointers. the weight to be attached to the grammatical meaning generally being far greater than applies to any other interpretive criterion. And we've put in just 2 pages from Benyon, which is at tab 25, page 1267. Turning to page 1268, section 9.4 appears, presumption in favour of grammatical meaning. And I'm certainly not going to read all of it. Can I just draw your attention to the following parts? The first sentence, prima facie, the meaning of an enactment which was intended by the legislature, in other words, its legal meaning, is taken to be that which corresponds to the grammatical meaning. And then dropping down under comment, the second paragraph, the initial presumption is in favour of the grammatical meaning since Parliament is taken to mean what it says. The presumption is of very long standing, being embodied in early maxims of the law. Broome cites the maxim, translated as where nothing in the words is ambiguous, no exposition of them shall be made, which is opposed to the words. And then under the heading at the bottom, weight to be attached to grammatical meaning. Grammatical meaning, at least of a modern act, is to be treated as preeminent when construing the enactments contained in the act. In general, the weight to be attached to the grammatical meaning is far greater than applies to any other interpretive criterion. The grammatical meaning may be overborne by other factors, but they must be powerful indeed to achieve this. On the facing page, under the heading Speculative Departures, there's reference to a case which I'm going to show you briefly in a moment, namely Lumsden, and then I ought just, for completeness, to draw your attention to the bottom of that page, under the heading the so-called literal rule. It will be seen from the above that there's no literal rule of interpretation in the sense that the grammatical meaning must invariably be followed. Determining when it is to be departed from is perhaps the interpreter's most difficult task. So, my lords, the first question is what is the natural or ordinary or grammatical meaning of the relevant word or phrase in its context. Now, leaving to one side, just for the moment, any broader context, the relevant words in section 110.3b are persons with legal qualifications, I pause, at least one of whom is not in active practice as such. Now, the requirement common to both appointees under section 110.3b is therefore that they must have legal qualifications. That much is completely clear. And clearly, I interpose, that requirement is satisfied by a judge or a retired judge. Next, one at least of the appointees must not be in active practice as such. And provided that is the case, there is nothing on the plain and unambiguous wording of the subsection in my submission to preclude a judge or former judge being appointed under the subsection. And my ladies and my lords, I would submit that that is so however you regard the phrase active practice as such. Even if the phrase were taken to mean active practice as an attorney rather than any other legal capacity. Once the person has legal qualifications and subject to the requirement that at least one of them is not in active practice as such, looking only at section 110.3b, a judge or former judge clearly qualifies. But, my lady, it is in fact by no means clear that the phrase active practice as such can or should be taken to indicate that the class of persons envisaged by the subsection is limited to attorneys practicing law. Had that been the intention, the legislature could very easily have so provided. Instead, it chose to describe the class of persons qualified for appointment as persons with legal qualifications. And it's therefore broader in my submission. And as has been observed, you can have legal qualifications, but not actually practice law. You can do other things. Now, as to the phrase that was chosen, persons with legal qualifications, it should be presumed that those words were chosen carefully and were used correctly and exactly by the legislature. And we've actually put in an authority for that proposition, which I don't think I need take you to, but for your note, is Spillers Limited, a dictum of Lord Hewitt, Chief Justice. It's at tab 14, which is at page 559. And the relevant passage starts at the bottom of page 80. There are no letters, and finishes at near the top of page 581.
You're coming on to it, but we haven't really concentrated on the words in B about the President consulting with organisations. Mr. Stevens, if B can include judges, who would be the organisations that the President might want to consult about them?
Well, I could answer that by saying if it were an academic or an arbitrator or some other person with legal qualifications in some other form of employment, who would the President ask? It's not entirely clear.
Oh, I see.
Well,
And why, if it's appropriate to consult organisations in respect of a possible appointment of a judge under B, why is there no provision for consulting organisations at the end of A?
Well, my Lord, the second answer I would give you is that what it in fact says is has consulted with any such organisations, if any, as he thinks fit. Now, those words could point, in the case of a prospective appointee who is a practising attorney, to the possibility of consulting, for example, his professional body.
Well, of course.
But if he's not such a person, there wouldn't necessarily be an organisation who the President would have to consult.
Thank you.
I had anticipated that reliance might have been placed on those very words, subject to the point I've just made, which is that the President doesn't have to do it, it's if any. I had anticipated that reliance might be placed on those words to suggest that the proper construction of subsection 3b would be that by persons with legal qualifications who are not in active practice, it points exclusively to attorneys. But the submission that I was just making was that had that been the intention, then one would have expected the legislature so to provide, because it could very simply have been done. And therefore, on the face of it, the provision is apt to include not just attorneys, but any number of people, potentially, who have legal qualifications. Now, it wouldn't matter on my argument whether, in fact, well, my lords, can I put it slightly differently? If the suggestion were that section 110.3b pointed specifically and exclusively to attorneys and didn't therefore include judges or other legally qualified persons, that would be conjecture and certainly wouldn't justify departing from the literal wording. It would be different if the legislature had chosen to use the words attorney or attorney at law or practicing attorney or something of that sort. So given, I'm sorry.
In Trinidad and Tobago, there are attorneys. Are there any other legally qualified people who would have an organisation?
Although I think I know the answer, I'd rather defer to Mr. Ram-Logan in that respect,
Yes.
my lady, because I shouldn't want to mislead you. It is essentially now a fused profession, but whether there are other people such as notaries, for example, I'm not sure. I don't know if Mr. Ram-Logan...
Just trying to make sense of the organisations, if it's
Yes.
an attorney who's being talked about.
Well, if it was an attorney that was being talked about, And if it were not the fused profession that I understand it to be, and you had barristers and solicitors, then obviously there could be potentially two regulatory bodies.
And I don't know whether it's
So-
changed since the Constitution was drafted.
Well,
So
may
these are
have
points
done.
really that
It
are local.
may have done, but I'm very hesitant to say any more about that. The short points that I make are essentially these. First of all, the legislature has very carefully chosen to refer not to attorneys at law, or barristers or solicitors or whatever other species of practicing lawyer you might choose, but to persons with legal qualifications. And that is obviously potentially broader and apt to catch, for example, a retired judge practicing as an arbitrator, potentially someone who had taken the legal qualification exams but gone into academia, or who'd done the same thing but gone on to employment in some capacity, potentially in the field of law, potentially not, and one can think of other examples. The second point is that the wording of the subsection that has troubled my lord and my lady is that the President has consulted with such organisations, I accept, if any, as he thinks fit, and therefore it does not follow that there is a requirement to consult with an organisation, and that doesn't therefore preclude some person with legal qualifications, in respect of whom there is no body who could be consulted, qualifying under the subsection. But it may not matter for the purposes of my argument, because even if one were to construe this as pointing to a person with legal qualifications not in active practice, meaning not in active practice as an attorney, clearly, in my submission, a judge would satisfy that requirement. If, as I respectfully but tentatively suggest, it is broader and deliberately so, being couched in the terms it is, persons with legal qualifications, not in active practice as such, a fortiori, it can include a judge as well as the other types of people to whom I have referred. If the suggestion were that it pointed, as I've suggested, specifically and exclusively to attorneys, based on the words not in active practice and potentially the words relating to consultation leading to that conclusion, it would potentially exclude from the ambit of section 110(3)(b legally qualified persons, in other words, people with legal qualifications, such as the types of people I've mentioned, arbitrators, legal academics, lawyers employed in other capacities. And equally, my lady, if it makes no sense to speak of judges in active practice or not in active practice, it makes no more sense, on one view, to speak of arbitrators, legal academics, or lawyers employed in other capacities as being in active practice or not in active practice. So how much assistance one gets from the words, if you test it in that way, it's far from clear.
Do we get any assistance from our own provisions in the Constitutional Reform Act, together with the definition of the qualifications for appointment? We might do.
Yeah, we might, and I'm ashamed to say it hadn't occurred to me.
Mind you, of course, we're thinking about 1976, whereas these are much more recent provisions, so maybe we don't get any assistance from them. But
well,
I'm dredging my memory for what...
I can't recall. I would have to look. I was going to make a point about the Relevant Legal Professions Act here, and that is that one doesn't find any definition of persons with legal qualifications, and it is a particularly wide phrase. And in my submission, therefore, apt to catch any number of people. And as I've submitted, it doesn't make any more sense, really, to talk about, if it catches such a person, a legal academic not being in active practice as a lawyer then, or it makes no less sense to say that than it does to say of a judge not being in active practice as a lawyer. As to, I'm just going back to the point my lady's just made about this being 1976, as to the suggestion, which is made against me, that it would have made no sense to the draftsman in 1976 to describe a former judge as a person with legal qualifications not in active practice. Apart from the point that it wouldn't have made much sense to describe a legal academic in those terms, even if, which I simply do not accept, that is correct, the argument overlooks the fact that statute, save in limited circumstances, and a fortiori, a constitution, is not frozen in time, but always speaking. So insofar as the code has been relaxed to permit the practice by judges of law, retired judges of law, then there's no reason why, if one looks at it as an always speaking provision, that cannot happen. And as I understand it, the relaxation has been to permit judges after a period of time to return to practice in the courts. But equally, as I understand it, there's no prohibition against a former judge acting in a capacity that does not involve litigating in the courts. I hope I'll be forgiven for not having put in any authority as to the always speaking principle, but if it were needed, one could cite any number of examples, possibly in the context of this case, R and Ireland, 1998, appeal cases 147, and of course, R and Secretary of State for Health ex parte, Quintervale, 2003, 2 appeal cases, 687. Now, my lady, I've been focusing solely, I realise, on section 110.3b, and I need to look also at the broader context, and specifically the context provided, if any, by section 110, and in particular, subsection 3a as a whole. The appellant's argument proceeds essentially, and I hope I do it no injustice, on the basis that first, section 110.3a establishes a distinct category of appointee, namely a judge or a former judge coming within the description of eligible judges, and provides that one, i.e. only one, the appellant says, such person shall be appointed. Secondly, that section 110.3b must therefore be read subject to section 110.3a, with the result that it, section 110.3b, does not permit the appointment of a judge or former judge. My answer to that argument is as follows. First, that there is nothing in my respectful submission in section 110.3a which leads to that conclusion, and nothing in section 110 as a whole, or in any extraneous material which hasn't been pressed, which requires the plain and literal meaning of section 110.3b to be read down. On a natural reading of section 110.3a, differing from my learned friend, I submit that it simply provides that the appointed members of the Commission must include a judge or former judge coming within the description of eligible judges.
In other words, your submission is that the essential purpose of section 110.3a is to ensure that at least one judge is included.
My Lord, it's not a freestanding provision. There shall be one judge. It's a provision which has to be read with section 110.3b. And as I submit on a natural reading of it, it simply provides that the appointed members must include one judge. It doesn't provide in its terms that only one such person can be appointed, and it does not preclude, therefore, in my submission, another judge or former judge of any description, not just the description contained in section 110.3a being appointed pursuant to section 110.3b.
So you could have, within the 5, the Chief Justice, number 1, a High Court judge under A, and 2 retired magistrates under B.
You could, my lord, but you could equally have a broader cross-section. Currently, as I understand it, there are two attorneys, one not in active practice. But yes, my lord, you could. It gives a discretion, effectively.
Yeah.
But, my lord, the difficulty with any construction, and I appreciate this is not exactly how the case is put against me, of section 110.3b, that it points only to 2 lawyers, one of whom is no longer in practice, is that you would then have 2 judges, the chairman of the commission, and 2 lawyers. Then you would be shutting the door to others with potentially valuable contributions to make, as has been widely recognised, such as academics, people working in other legal fields.
So
Now,
why is an academic not somebody with a legal qualification, not in active practice? You said that before.
No, I haven't said that he isn't. I've said that he could be, provided he has a legal qualification.
Whatever that may mean.
Whatever that may mean.
And
But
is it
the
limited
point,
to legal qualifications in Trinidad and Tobago? Because one notices that the judge could have been a judge or be a judge from anywhere in the Commonwealth, as long as it's a high enough court.
he could be.
Oh.
The best sense I can make of it, given the words not in active practice as such, is that it would have to be a legal qualification that would entitle you to practice. But it does not follow that you have to have ever been in practice.
Yes.
I hope that's that's my reading of it anyway.
And would you limit it to Trinidad and Tobago, or would you say, because there's no reference to anywhere in the Commonwealth,
Well,
in B?
I don't need to
You don't need to do that,
to make that proposition
all
good
very
for the purpose.
interesting.
But my lady, insofar as it interests the court, I would respectfully submit that you could make a strong case for someone with a legal qualification that would, according to the law in Trinidad and Tobago, permit that person to practice law in Trinidad and Tobago and or to be a judge in Trinidad and Tobago. I think that's the only sensible answer I can give to the question, but as my lady's accepted, I'm not sure I need to go that far. The point...
Well, I was trying to get at, why have these 2 separate paragraphs? What are they looking for? That's
Well, my lady,
the heart of it. And
I entirely accept that, and let me
because
accept...
otherwise, one could just have had B saying at least one of whom must...
Three appointed members, at least one of whom shall be a judge or former judge.
Yes.
Yeah, my lady, that could have been done. But one is, I haven't shown you Lumsden, one can't conjecture, one needs to look at the words, and if one looks at the words, on the face of it, a judge, it's not suggested that a judge or former judge is not a person with legal qualifications, whether those be legal qualifications recognised in Trinidad or somewhere else. That's not suggested. A judge meets that requirement. A judge or former judge is not in active practice as such, or at least provided he isn't, he hasn't, for example, returned to practice, is clearly within section 110.3b. And insofar as I've suggested that section 110.3b is in fact to be read more widely, not as focusing only on practice as an attorney, but on practicing as an attorney if you have a legal qualification, it could include any number of people who, on the face of it, would have qualified to practice as a lawyer or would have qualified to become a judge, but have gone down some other route. And if that is right, if it is to be construed in that way, all the more reason for it to include a judge. There's simply no way you can read this provision without conjecturing as to what might have been the intention or what Parliament might have meant but didn't provide, and get to the conclusion that 110.3b excludes judges.
If you have a judge within B and the judge is still in post, do they fall within B?
yes, he could, because on the wording of 3B, he would have a legal qualification.
It wouldn't be
Only one of them has to be not in active practice. If that points to practice as an attorney, clearly he would not be, and it wouldn't matter if the other were. If in fact it were to point to practice of the law as a judge, then obviously a different question might arise. Then you might have to say, well, it would depend on whether the other person was practicing law, but I'm not submitting that that is the meaning of it.
You don't normally talk about judges practicing law.
No, you don't. You might talk about a former judge who's developed an arbitration practice, practicing law, potentially, but I mean, that's the only example I can think of. So. Now, my lords, on the one or only one reading that my learned friend suggests in relation to section 110.3a, what he submits in his printed case, at any rate, is that the word other should be read into subsection 3b. So, in other words, as I understand the submission, it should be read as two from among other persons. Well, now, my lady, there's no more reason for implying that word into subsection B than there is for implying the word only into subsection A. The provisions read singly make sense. Read together, they make sense. Literally, grammatically, on their ordinary wording, they do not exclude a judge. The reality, therefore, is that on a natural reading of section 110.3, the clear purpose of subsection 3a was to ensure, as my Lord Kerr put to me, the presence on the commission of a judge or former judge, coming within the relevant description. And subsection 3b, on the other hand, creates a wider pool of candidates for appointment which may, but does not have to, include a judge or former judge. And if that is right, they are not distinct, special and general, respectively, provisions, but overlapping provisions. Overlapping in as much as a judge or former judge coming within the description in subsection A can also be appointed pursuant to subsection 3b. And if that's right, the Latin maxim, translated as general provisions do not override special ones, has no application. And that was exactly what was found to be the case by Lord Neuberger in the Cusack case that my learned friend sought to rely upon. It's paragraphs 56, 57 and 61 at tab 7, page 379. There's also a submission made, at any rate in my learned friend's printed case, I can't recall whether he mentioned it already, I don't think he did, which relies upon the Jamaican constitution, which you've got at tab 3, which is in the bundle of authorities, volume 1, at page 329. It may just be interesting to pause and look at that. There are material differences, obviously, between section 110 of the Trinidad and Tobago Constitution and the equivalent provision, section 111 at 329 of the Jamaican Constitution, apart from the obvious fact that the Jamaican Constitution provides for 6 members and includes 2 judges as ex officio members, the Chief Justice and the President of the Court of Appeal. Trinidad and Tobago doesn't have a President of the Court of Appeal, I would just make that clear. Section 111.3b requires the appointment of 2 members from a list of 6 persons, none of whom is an attorney at law in active practice. Whereas, of course, our section, section 110(3)(b) of the Trinidad and Tobago Constitution, refers not to attorneys but to persons with legal qualifications. So far from deriving any assistance from it, there is in fact a distinction made in the Trinidadian, I should say Trinidad and Tobago Constitution, and I've already addressed the board ad nauseam in relation to the words with legal qualifications. But those
So in Jamaica, they're not actually allowed to have
no.
practitioners.
Well, not in that category, no.
Well, but where else would they be?
Well, no, you're right, my lady. But, yes, so there are two other people, neither of them can be.
What's the date of that provision, Mr. Stevens?
Well, I think I'm right in saying that the Constitution of Jamaica is 1968, is it? That's off the top of my head.
Very well, thank you.
Wrong. Can I tell you after lunch, my lord?
Thanks.
At any rate, my lords, I've made the submission I have about the deliberate choice of the words persons with legal qualifications. Finally, can I just say a word under this submission in relation to policy considerations? Clearly, competing arguments can be made, not only those advanced in writing by the appellant based on the various authoritative materials concerned with the appointment of judges, which the board has, but also, in my respectful submission, those peculiar to a small jurisdiction such as Trinidad and Tobago. And two of the three judges in the Court of Appeal alluded to that. Can I just direct your attention to those two passages? First of all, at page 192 of the record, in the judgment of Justice Appeal Mendonca at paragraph 59, course of argument, Mr. Roach for the Commission reminded the Court that the appointing authority is the President. The Commission does not appoint itself, and in a small, society as ours, it is oftentimes difficult to find suitable persons willing to find the positions. In the meantime, it cannot be expected that the Commission would cease to function. The suggestion was that efforts were being made for some time for someone to fill the position. Well, I don't push this point very far because it can't assist you ultimately in construing the provision, but certainly a construction that permits not only of the various other types of people I've mentioned, but also of the appointment of a judge under 110(3)(b, does meet potentially the concerns there alluded to. The other passage is at page... I should say that... I'm not entirely clear what is meant by prospective breach of the Constitution, but when we get to that, rather than taking you back to this very passage at paragraph 59 makes it clear that there was a suggestion that efforts were being made for some time for someone to fill the position, in other words, the vacancy, because certainly there's no suggestion in evidence or otherwise that there was any deliberate decision taken to operate only as a four-person commission. That was no part of this case. I digress. The other passage is page 207 of the record, at paragraph 86. It's just the last two lines where Justice of Appeal Barrow said, "Ours is a small country. Finding suitable candidates to sit on the commission is not always quick or easy. Catchment of candidates is small." My lords, I can just give you the answer in relation to the Jamaican Constitution. It was the 25th of July, 1962, not 68.
Thank you. Sounds more likely, yes. They haven't changed.
Well, it does. It makes considerably more sense, yes. My lords, I was just briefly on, my ladies, my lords, I was briefly on the policy point. the short point is that however strong any such policy arguments may be, they can't be determinative in the face of what I submit is the plain effect, even if it's not the simplest way in which it could have been enacted, of section 110.3b. And in particular, to conclude in relation to section 110.3b, it is, in my submission, simply impossible to extract from the wording of the subsection on its own or read in conjunction with section 110.3a that no one other than a member of the legal profession may be appointed, or that, even if the pool is wider, as I submit it must be on that wording, a judge cannot be appointed. You simply can't get there reading the language in the natural way which the authorities suggest it should be.
Could I just, before you finish on that,
Yes, my
ask
lady.
you what statute or other provision deals with the appointment of judges and the qualifications that they have to have? I'm asking because I'm still thinking about the meaning of legal qualifications, and if you look at 111,
Yes.
it's got exactly the same phrase in that connection.
Yes. Well, the Constitution certainly provides for the appointment of judges. It doesn't deal with the question of qualifications. I will have to research that and respond.
I've just taken it from 111 subsection 4.
There's a piece of ordinary legislation that deals with that.
I'm sure there is, but without researching it, my lady, I'm very
I'm just
sorry.
looking for the meaning of legal qualifications, and you'll see why I've looked in that section when you look.
No, I do.
I don't need the answer now.
No, my lady, I'm afraid you're not going to get the answer now, but can I research that and provide the court in a neutral way with what legislation there is relating to the qualification required for judges? Is that the easiest way? I think it's the only way in which I can deal with it after the hearing, I'm afraid. My ladies and my lords, for all those reasons, in my submission, the Court of Appeal was correct to determine the appeal as it did. I would only add that the reasons are, in my submission, aptly, if not entirely fully, because I've said a few extra things, encapsulated in the judgment of Justice of Appeal Mendonca at page 185 of the record in paragraph 42, but I shan't take you to it. You've obviously read the judgment. My lords, can I now come to section 36? I confess that I've been slightly taken by surprise by the way in which this submission has been advanced, because whilst in the statement of facts and issues the appellant contended that, as he did in the Court of Appeal, that the functions of the Commission can be lawfully conducted with a quorum of 3, he submitted or contended in the Statement of Facts and Issues that that was only so if the Commission was properly constituted. In his printed case, he now says, and I think in substance he said this orally too, that the Section 36 argument is to some extent academic now. But, he says, in his printed case, the very fact that in certain circumstances Section 36 prevents acts of an improperly constituted commission from being retrospectively invalidated ought to have weighed in favour of the interim relief, and certainly in that respect it's now academic. The significance being, though, that in his printed case he accepts, at any rate, that in certain circumstances the effect of Section 36 is to prevent the acts of an improperly constituted commission from being retrospectively invalidated. And I don't think he's departed from that. And therefore, insofar as Section 36 is a live issue, it's only a live issue in the narrow way that my learned friend has alluded to. And in that respect, he refers to what he describes as a prospective breach of the Constitution. I confess, and I'm quite sure it's me, that I'm not entirely clear as to what he means by that, but I apprehend that he means operating with 4 members, effectively. But as I mentioned when showing you paragraph 59 of the judgment of Justice of Appeal Mendonca, this case wasn't about any deliberate operation of the Commission with only 4 members. There was no suggestion of that. There is no evidence of that. The point that was taken below, and in my learned friend's case, was that a vacancy, if it was a short-term vacancy, effectively, he submitted, might be dealt with by Section 36, but if it was a long-term vacancy, it might not be, and then obviously the question arises as to where you draw the line. But as I say, I struggle a little to understand exactly what he means by a prospective breach. Our position in relation to Section 36 is quite straightforward. So far as the number of appointed members is concerned, first, we take an evidential point, and that is that Justice of Appeal Mendonca held, and we submit was right to hold, that there was in fact no evidence that the Commission comprised only 4 members at any material time. Now, I say that because if your Lordships look at page 189 of the record, and specifically at paragraph 53, one finds this. In relation to the appointment of judges, Section 104.1 of the Constitution provides that they shall be appointed by the President acting in accordance with the advice of the Commission. I think Mr. Ramlogan was correct when he submitted that it is a fair inference that at some point a 4-member commission would have been involved in the selection process of the successful applicants for the office of judge. But this does not mean that the advice of the Commission to the President in accordance with Section 104.1 was given by a 4-member commission. Mr. Coilas was appointed on the 17th of May. On his appointment, the Commission was at full strength numerically. At about the same time, at the commencement of these proceedings on June the 5th, there was a notification that persons were to be sworn in as puisne judges on the 6th. It's therefore appropriate to infer that at some time prior to the announcement, the President was advised by the Commission in accordance with Section 104.1, but there is no evidence when the Commission acted in accordance with Section 104.1.
But Mr. Stevens, bearing in mind there were only 4 members for a year, 18 months prior to 17 May 2017, didn't the evidential onus shift to you to show that, in fact, the crucial step was taken after 17 May?
Well, no, that's obviously not what the learned judge said.
No, it isn't.
And
no.
your Lordship's read ahead and seen what he said, which was contrary to that. My answer to that would be there was some evidence alluded to in the very paragraph that I've shown you, paragraph 59, that it wasn't in fact easy to fill vacancies, and the search had been on for some time. I say evidence, I can't be sure that that was in evidence as distinct from being a submission made by counsel.
Well, the difficulty of filling the appointment is not the point we're on, Mr. Stevens.
No, my Lord, we're not, but as I understood what was said against me in relation to a prospective breach was that effectively the Commission was operating with only 4 members.
Yes.
That may be right. The first answer I gave to that was there was no evidence that that was any sort of deliberate or other than bona fide process. The second point is that there is, whether it's evidential or not, paragraph 59, which I've shown you. And the only additional point I'm seeking to make, Your Lordship may not think it a good point, was that one, at least, of the judges was not persuaded that the actual advice tendered to the President was tendered...
Well, there we are. You've reminded us of that point. You might like to move on.
I was going to, it's a short point.
Yes.
Can I just
My
ask
Lord.
you about the prospective
Yes,
breach of
my
the
Lord.
Constitution? The Commission makes a recommendation to the President, is that right? And the President does the appointing
Yes, he does.
on the advice of the Commission under Section 104. So the Commission's role was finished. If it was in breach of the Commission when it made the recommendation, it was a past breach, not a prospective breach, wasn't it?
Well, my lady, yes, that would follow.
The prospective
This-
breach was what the President was going to do.
Yes, which in fact was never done because of the injunction.
Yes.
And then the very speedy hearings that ensued. I mean, my lady's articulating in a specific way the point I was making more generally. This case wasn't about prospective breach. At any rate, I don't understand it to have been, and I don't understand how my learned friend can really derive from what happened in this case anything which could have amounted to a prospective breach.
It depends
There
whether
was-
the connotation of perspective goes beyond deliberate. I mean, you've been at pains to say that there's certainly no evidence that this was deliberate. But I suppose it might be argued by the appellant that if you are aware that the Constitution requires that there should be a 5-member panel and you go ahead with a 4-member panel, that may not be deliberate in the sense that you don't intend to disobey the requirements of the Constitution, but you consider that you probably would be all right. That's prospective, isn't it?
On the Lord, in tendering the advice in those circumstances, my Lord.
Yes, the other thing about, I've just been reading the affidavit of Mr. Maharaj, and his letter before action preceded the appointment of Mr. Coilas, isn't that right?
It did. There was then the appointment, and then on the following day the reply.
Yeah. But that,
We've only got the first page of the letter for action, but we have got that.
But just reverting to the point made by my Lord Wilson, that rather suggests that the consideration of the appointment by the Commission would have been before his appointment. And that therefore, I don't think that the respondent filed any affidavit in the proceedings, is that right?
I think that is right.
Yeah. So far as Mr. Justice Seepersad was concerned, the allegation was made, implicitly at least, that there must have been consideration of the appointment before the commission was a 5-member commission. And if the respondent was going to challenge that, you'd expect the respondent to file a replying affidavit.
Well, what was objected to was the composition of the commission. That may have been triggered by the prospective appointment, imminent appointment of the 2 judges, but I'm not sure the 2 things are necessarily linked.
Yeah.
And the case was not about the question whether there was any breach of the Constitution by virtue of the operation of the Commission, whether deliberately or otherwise. It was about the question whether a judge was qualified to sit on the Commission under Section 110(3)(b).
Well, I rather hazard that the outcome of the case isn't going to depend critically on the resolution of whether there was evidence or not.
Well, my lords, I see that. Can I just move on to deal with a couple of other points? I, in any event, submit that as the Court of Appeal held, decisions made by the Commission when it comprised 4 members due to a vacancy, and there's no basis on which you can approach it other than that, were nevertheless valid. And I say that because that is the clear effect of Section 36(1)(d) of the Interpretation Act, And whilst I can see that some deliberate decision to have only 4 people and continue operating in that way might amount to a breach of the Constitution, I don't accept that a vacancy, and that is the only basis on which it can be looked at on the facts of this case, attracts any such negative imprimatur. If it is a vacancy, it is squarely within section 36(1)(d) of the Interpretation Act. I would add, it being common ground, that the functions of the Commission can be conducted provided there's a quorum of 3, and there's obviously no suggestion that there were ever less than 3, less than 4, let alone less than 3 members. My Lords, you were shown the side note to the section which Lordships have at page 3, my ladies and my lordships have at 336, defect not to invalidate acts done in good faith. And it was suggested that that can only apply to past acts, because you have to have a determination as to whether it was done in good faith or not. And therefore this can't apply, if it is in any way an issue in this case, to a prospective breach. And you were shown the decision of Montilla and others. Can I just draw your attention to a provision which you haven't been handed, because although we were sent Montilla, we weren't entirely sure what the significance was, because there was no submission in writing, and I don't make any criticism, my own friend, for that, no submission in writing on this point. We nevertheless had a look at the Interpretation Act. Could I ask that section 11 of the Interpretation Act be handed up?
Well, we're just about on time for the short adjournment, Mr. Stevens. Would you like us to look at it now or later?
It's more convenient to look at it later, because I've got a few more minutes.
You've got a few more things to say.
Yes, I have. Not a great deal, I must say.
No.
And I'd be happy to continue, but my lady, since it is that time and I hadn't realised that, shall we do it after the adjournment?
You often get into the flow, so it's difficult to recognise
If he
the
was
time.
going to be 5 minutes, and if Mr. Clayton, who's usually short, is going to be 5 minutes in reply, would there be something to be said?
No, definitely not. Some of us have got things we must do.
Lady, I'll leave that until after the short adjournment.
But you heard, my lord.
I did. And
And no doubt Mr. Clayton did too.
And neither thing will be longer than 5 minutes.
I've already indicated I'm not going to be very long, and I'm not, my lady.
We look forward to hearing from you.